Well, tomorrow evening seems to be the only time that works, given the 11-hour time difference. I had thought it was 7 o'clock, but you said 7:30.
I think it was 7 or 7:30, but I was there told 7:30.
Well, if it can be 7 o'clock, that's a plus. If it has to be 7:30, that's what they said.
Well, the Lordship should have received some further statements that were served in the last few days. The Lordship should have had a third statement that was not there, which hopefully has found its way into Bundle A at tab 25A. Page 179.1.
Yes, I got that.
And then there should be a statement from Mr. Cheniza at 34A at 274.1.
Yes, I got that.
And then finally a fifth statement from Mr. RELLA, which is one I think behind that at 274.4.
No, if it's not there.
Well, we'll make sure that that's in the leadership shortly. Well, we wrote to Alan and Overy yesterday, giving them notice that we intend to include in our claim, in the employment of the claim, airfares that we say are a benefit that Mr. RELLA became entitled to. I understand that that's not objected to, and we offer to make a short amendment. I don't know whether there exists on amendment being made, but subject to your worship, if it's necessary, just a few words to make clear that the attorney claim.
In the counterclaim?
In the counterclaim, yes.
Well, I think it would be helpful to have that.
What we will do. And lastly, and possibly some irritation, Your Worship, there are two core bundles competing. And I wasn't going to say anything about that, say to ask Your Worship which core bundle Your Worship preferred, and I will then make sure that all my references are aligned with that core bundle. There's a spiral bound core bundle and a ring binder from the claimants.
I haven't got a spiral button run.
Should look like this.
No, I haven't got it.
Well, let's solve the issue. Does Your Worship have the other one?
No, I've just got the witness statement. I've got a ring cover of claimant's proposed core bundle in a ring cover. In a Liberage fund.
Oh, yes.
Well, I hadn't got this one.
Does Your Worship have a preference for which of those? They're very small.
Well, hardly, since I haven't seen this one before. Have they got the same documents in them?
Ours, I think, has got slightly more.
We just want to go to the relevant parts of the core agreements, whereas they've got full agreements in. So ours is slightly shorter, but it's not otherwise in the sequel agreement.
Right, thank you. Well, if they've got the same documents in them, but this has got slightly more, and this is in spiral form, I'll use this one. Let me just find a pen for Mr. Rella's fifth statement. Getting bundle A.
At the very back of Bundle A.
Well, you better go in that's where the hedge is.
Yes. We say there are three battlegrounds in the case. There's the unfair prejudice dispute, which your Lordship indicated is the primary battleground, we agree. Secondly, there are the employment claims. And then thirdly, there's this dispute over the use of the name ROBERTO'S and the trademark. Well, I was going to address your Lordship under 5 headings by way of opening. Firstly, I was going to just show your Lordship some of the local law that the parties rely upon. Secondly, have a look briefly at the contractual documents. Then thirdly, explain how we put our case in a nutshell on the unfair prejudice aspects. Fourthly, on the employment claims. And fifthly, on the trademark, or the use of the name ROBERTO'S issue. Or, in relation to local law, does your Lordship have 2 bundles of authorities that you want to claimants?
There's the ones that remain around this morning.
In the second one, there is all the relevant provisions of the both the federal law and the IFC law. And you'll also see there's an interesting conflict issue that arises in relation to the trademark part of the dispute, because of course trademark law in relation to trademarks is federal law and is not within the domain of this court. But of course, part at least of the contractual documents deal with the use of the name ROBERTO'S, and they are subject to your Lordship's jurisdiction. And we say there's no difficulty there. We say your Lordship can adjudicate on the private law aspects of the trademark dispute without in any way encroaching on the statutory federal law. But we're just setting up then the distinction between federal law and the IFC law. We start with the federal law of 2004 number 8, which should, in a moment, I've been using. That is in tab 22, I think.
Yes.
We see this is the federal set up a free zone, and we see at Articles 2 and 3. Article 2 establishes the free zone and its governance by body corporate. And Article 3, 1, says that the free zone is subject to everything in relation to money laundering regulations, and then 3.2 carves out the jurisdiction of the free zone in relation to civil and commercial laws. So the default position is that federal law applies even in the free zone, except for matters that are civil and commercial. And while we're looking at federal law, if I can just show your Lordship the trademark federal law, and that is at tab 21, the tab before that. And if I can just show your Lordship by way 2 and 3 define what can be and what cannot be a trademark. So that's a matter governed by federal law, statute. And then Articles 6 and 7 govern the right to register a trademark. And I don't want to go through this, but we quite accept that all of those matters are matters of federal law and not for your lordship. But if we say if parties create private rights around a trademark, for example, they agree to sell the trademark or they license the trademark, and those agreements are governed by DIFC law, we say that your lordship does have jurisdiction. We say that's carved out under law number 8 of 2004. Otherwise, the result is absurd, because it means that the parties can enter into a contract in relation to their dealings in the DIFC. They can intend and stipulate that the DIFC law and jurisdiction applies to it. But it would mean that the DIFC courts could not enforce or recognise the private rights that are created. So, well, that's federal law. When we turn into the DIFC law, we need to look at tab 14. I call this the DIFC law, a short law on the application of civil and commercial laws in the DIFC. And the provision that both sides rely on in particular in relation to penalty clauses and the like, is at Article 8. And I'm sure you all should have looked at this before. It creates this sort of cascading effect. You move through Article 8.2 and you stop at the point that the subparagraph provides for the law that you apply. So 2A, you start with regulatory provisions, and so you apply either the DIFC law or other law in force. That could be federal law. This doesn't apply here. Then you go on to B, the law of any jurisdiction apart from that of the DIFC expressly chosen by any DIFC law. That doesn't apply. Then you go to C, the laws of the jurisdiction is agreed between all relevant persons concerned in the matter. Well, some of the agreements here were governed by DIFC law. And then you go to D, close connection. So that would apply to a contract formed in the DIFC about the DIFC, but that didn't stipulate a choice of law. We would say DIFC law would apply there. And then the fallback is to the law of England Wales. That's the DIFC law on the application of law. But as your lordship will see, there's also another route to English law that Mr. Justice Coleman recognised, and he said, I'm not going to look at it, but he said you can also apply English law if the DIFC law is modelled on and so close to English law that it's clear that the principles are being borrowed from English law. You can then look to English case law by way of assistance to the interpretation and application of DIFC law. So those are the laws on the complex aspects of the case. If I can then just briefly look at the company's law. Company's law is at tab 19. And as far as I can see, this doesn't differ at all so far as it's relevant from English law. Article 53 fiduciary duties and also their duties of skill and care. Article 54 is the duty of disclosure of directors' interests, exactly the same as English law. And then Article 133 is the jurisdiction to order a party who's in breach of duty to compensate. And Article 134 is the unfair prejudice article, which is in material respects identical to provision in the 2006 Companies Act, Section 994 of the UK. A very broad discretion and a very broad ambit, Your Lordship, to give remedies that meet the justice of the case. And we say this includes powers that Your Lordship would have to right any wrongs in relation to the use of my client's name and the trademark. Your Lordship believes that that's part of the unfair prejudice. Your Lordship can use these very broad provisions to do justice in the case, we say. Well, the contract law is at tab 50. Now this does, in some respects, look in English law, and it's useful just to flag those points up. So if we look at 37(1)(a), now that's a mistake. And we do rely on mistake orders. I said in my opening, a fallback position. As I read 37(1)(a), that broadly aligns with mistaken equity in terms of unilateral mistake, i.e. a mistake by one party that for whatever reason operates on the conscience of the other party. So if they know of the mistake, it's an obvious mistake, and they take advantage of that, that would be give equity a ground to interfere. So that aligns with English law. Article 46 is partial avoidance, which we seek of the relevant provisions. That's straightforward. Article 51, that's the rules of construction of the DIFC, and this is substantially more liberal than the rules of construction in English law. So, for example, Your Lordship can have regard to the preliminary negotiations between the parties at 51A. Your Lordship can have regard at 51C to the conduct of the parties subsequent to the conclusion of the contract, something that the House of Lords in Whitworth Estate said was not permissible. And the rest probably are in line with English law. But that gives Your Lordship far more freedom in construing the terms of the contract than would be the case if we were sitting in London. Article 57, implied obligations. Again, this is a more liberal approach, we would say, than English law. So implied obligations arise from the nature and purpose of the contract, practices established between the parties and usages, seek good faith and fair dealing, and reasonableness. Now that's a much lower threshold than business efficacy, obviously necessary. Article 58 is a duty of cooperation. Now that's recognised normally in the kind dicts, isn't it, as an implied obligation, but it's there made clear. Article 63 I will be relying upon. So where a contract doesn't provide a provision, we say, for somebody to terminate by notice. The contract law implies a reasonable notice period. And I rely upon that for our 90-day notice period. We say it's a reasonable notice period. And then Articles 109 through to 123, they have actually been reenacted in the Damages Act. And I'll look at that in the Damages Act. But they're in the Contract Act and then they're reproduced in the Damages Act. So if we look at the Damages Act next, and that is at tab 70. Now, what I say about this Act is that it's a code. I say that this is a comprehensive code for damages or remedies that are available in the IFC. So, if parties are going to stipulate for the consequences of a breach of contract, and it's governed by this code, they have to bring themselves within the code. I don't need English law for penalties. My primary position is I get to where I need to get to simply on the basis of the local law. And we say that the code, this Act, at Article 8, provides for a right to damages in conjunction with other remedies where there's non-performance. And that then follows through into Article 10, which stipulates how those damages are to be arrived at. And we say that the rule as to penalties and liquidated damages is codified in Article 21. And Article 21.1 says, where the contract provides that the party who does not perform is to pay a specified sum to the aggrieved party for such non-performance, the aggrieved party is entitled to that sum irrespective of its actual loss. So there we have liquidated damages. Now I know my learned friend will say, oh well that's to pay a sum, that's not forfeiture of shares as we have in this case. But what I say to that is, I say, well, you have to bring yourself within the code. And you make your choice. Either you say Article 21.1 sum means also money's worth, and that's English law. English law says that a penalty can be a sum of money or money's worth. Very well established. And if you can't do that, it's not within the code anyway, so you fall flat on your face before you get here. I would agree that giving sense to this, Article 21.1 has to mean a sum of money or money's worth, because it would be so easy to evade this part of the code if it didn't mean that. You could easily come up with other sort of ways in which you get your penalty, but not with a sum of money. So, Article 21.1, we're in this territory, I say. And then Article 21.2, however, notwithstanding any agreement to the contrary, the specified sum may be reduced to a reasonable amount. And here's the test where it is manifestly disproportionate to the loss envisaged as capable of resulting in relation to the loss resulting from the non-performance of the other circumstances. That, I say, is a codification of what in English law we have as law against penalties. And my learned friend has either to say that he does say the IFC law has no provision in relation to penalties, and he's wrong about that because it plainly does. That's what his pleadings say. It plainly does in 21.2. Or he says that he's successfully evaded it. And I say my primary position is he hasn't. My fallback position is, if I'm wrong about that, and he has managed to wander outside of this code, then I say, well, I can claim evidence law under Article 8 of the GIFC Law of Laws, and we go down the cascading effect because there's a lacuna there, and I say that the lacuna can be filled by English law, and I can rely on penalties on that level. Well, just heading
Are
on.
you relying at all on the principles of English law which enable a court to relieve from forfeiture?
Do I?
Yes, do.
Well, I did think about that. Came to the conclusion, we haven't pleaded that. Come to the conclusion that we don't need to.
You don't rely on relief.
I don't rely on it, unfortunately.
Well, that's interesting, because it would seem to me that if this was a case in which there was to be granted relief, it was almost certainly relief from forfeiture rather than non-enforcement of a penalty. But you don't rely on relief.
Well, I don't. I don't because, for two reasons. Firstly, the laws, the penalties are sufficiently clear that we say to get us home.
Well, that depends on whether you regard this, whether the court regards this as a penalty provision at all.
Well, it does. But also, the jurisdiction under Article 134 of the Companies Law is sufficient.
Well, I shall simply record that you don't rely on the English doctrines of equity relating to relief from forfeiture, and I don't need to be concerned with it.
I know. Well, can I just have a think about that?
Well, I thought you had, Mr.
I had thought about it more, but I'm being told to reserve the position.
But you've been told to think again.
I think so.
Well, shall I not write down that you don't rely on the English law doctrines?
You should write down that I initially told the Lordship that I didn't. But I've taken instructions and asked. I've just reserved my position. Well, in relation to, if I just sort of meet another point that may be coming my way, I suspect it will be said by the well, the damages and remedies law gives other remedies as well. It's not just damages. It gives, for example, scope for injunctions and declarations and the like. But more, those are all concerned with enforcement of primary obligations. The point about damages is it's a law, it's an obligation that arises as a secondary obligation for breach of primary obligations. And so we say that this law contains a comprehensive code governing how a party's secondary obligations are to arise and the extent of those secondary obligations. Well, I need to show you also Article 48 in relation to restitution. The learned friend on the hospital expenses says, well, if there wasn't an agreement that they be repaid, he claims them back by way of unjust enrichment. And that again is subject to the code. Article 48, restitution available where the remedy is expressly provided in the IFC contract or where there has been unjust enrichment of one party at the expense of another, and there's been no subsequent change in the position of the enriched party, which would render it unjust or the enriched party to restore the benefits received. We need to look at the employment law, that's tab 18. 36. There's a right to terminate where an aggregate of 60 working days are taken off by way of sick leave. In our contract, we were afforded 90 days. And then Article 59 59(2) provides minimum notice periods. I say that I can do better than these minimum notice periods by relying on Article 63 of the contract. I say that I can get to a reasonable notice period in 90 days. Article 59A. Now, this is headed termination for cause. And I say that cause under the statute is different to cause under the contract. And I'll show you what I mean by that in a moment. But if we just look at Article 59A, termination for cause, an employer or an employee may terminate an employee's employment for cause. And here are the circumstances. In circumstances where the conduct of one party warrants termination, and where a reasonable employer or employee would have terminated the employment. That's cause in the statute. If I show your lordship the employment agreement, and that's in lordship's tab 4. Lordship turns to clause 8, which is headed end of service, which is at short pages at 52. Now, clause 8A, should the second party decide to resign, a notice period of not less than 3 months, 90 days must be given in notice in writing. Either party should be entitled to terminate the contract during the probation period of 5 days' notice. Then B, termination for cause, and that's capital C. Termination for cause, voluntary termination, expiration of the employment term. The employment term and the executive's employment partner may be terminated, one, by the company for cause, that's a defined term with a capital C, by written notice specifying grounds for cause in reasonable detail. And 2, you don't need to worry about that. Executive's employment shall be terminated at the end of the employment term for either party hereto giving the other a notice of its or his desire not to extend the employment term in accordance with cause shall mean. And then there's a set of circumstances that are cause under the contract. And then if your lordship skips down to D, an employee is not entitled to gratuity payment where the employee has been terminated for misbehaviour. That's a different concept. A termination for such cause, now such cause is misbehaviour, and that's a small c, that's not the cause in 8b. A termination for such cause, i.e. misbehaviour, exists, now here are the circumstances, where the employee's conduct warrants termination and where a reasonable employer would be terminating the employee. Those are the words taken from Article 59A of the Employment Law. So, quite important to distinguish between these concepts. We have under the contract, we have cause, and we have misbehaviour. And misbehaviour aligns with cause under the Act. And it's important because we shall say that serious cause is a reference to B. So, in the shareholders' agreement, when it talks about a dismissal for serious cause, we state that that is a dismissal for a cause under a plea that is serious. And my Lord, the distinction in the employment contract is important because for misbehaviour you can be dismissed without notice and you forfeit your gratuity, but for cause you do not forfeit your gratuity and you are still not, you still get notice period. If notice period is applicable. And we also say that therefore it must follow logically that 8b, circumstances which amount to misbehaviour are more grave than circumstances that would simply be a cause under 8b. 8d is more serious than 8b. And I'm going to say that Mr. RELLA, the other side can't even bring themselves within 8b. Also, they don't even get there, let alone misbehaviour, let alone serious cause. They don't even get into 8b. And if I'm right about that, I will. Now, well, I was going to look very briefly at
Well, something seems to have gone wrong with the drafting in the first paragraph of letter B, hasn't it?
yes.
The first part of that paragraph provides that the employment term can be terminated, one, by the company for cause, and two, by the executive voluntarily.
Yes.
And then it goes on to say the executive's employment shall be terminated at the end of the employment term, which is what you might expect, following either party thereto giving the other a notice of its or his desire not to extend the employment term. You might expect there to be a stop on
Yes.
then you get in accordance with, quotes, cause shall mean. And it's not very obvious what those words are actually doing.
Well,
Cause is said to be a defined term, but if so, then you would expect the words, quotes, cause, quotes, shall mean to be a separate sentence. But how do they link into in accordance with? And it just doesn't seem to be a terribly cleverly drafted provision.
Well, I agree. We would say, we would agree with your Lordship's initial observation that what's needed is a full stop between the word term and in, and then it does make sense.
Well, even if you put full stop there, then you have a sentence which starts in accordance with cause shall mean. In accordance with what?
But if your Lordship goes back to the first two lines of the previous paragraph, the employment term and executive's employment hereunder may be terminated by the company for, and then cause in inverted commas with capital C, as defined below. And then it goes on, and then a bit later down, insert full stop. In accordance with cause shall mean. In other words, here's the definition that was referred to earlier.
The phrase "in accordance with" cause isn't defined. And it isn't the term. The relevant term is cause. Anyway.
Well, yes, I take that point, but the inverted commas around the word cause, and it doesn't have a capital C. And the inverted commas are used.
Well, I just make the observation that if you're going to rely on some distinction between paragraph little b and paragraph little d, one has to have in mind that this isn't a very cleverly drafted provision anyway.
Well, I accept that.
Sophisticated linguistic submissions and differences don't sit very easily with this draftsmanship.
Well, we would say that it's not a terribly big leap to put a full stop in that paragraph. It's clear that the parties intended cause to be a defined term. It's clear that the subparagraphs A to H are referable to the meaning of cause because they follow the three words cause shall mean. I accept there is some ambiguity or difficulty with the words in accordance with, particularly in having a small line. And I do accept that there are some drafting glitches. I think I picked up another one actually that Mr. Robert points out. If your Lordship looks at Articles Clause C, 8C, it refers to the end of service gratuity in accordance with Article 60 of the DIFC Employment Law. In fact, that should be Article 62. So I accept that it's not a perfectly drafted instrument, but I would say its meaning is reasonably clear. What the parties are intending to get at. Well, I'm going to look briefly through the key contractual documents. I'm going to start with the May and July agreements. They're in your Lordship's core bundle at tabs 1 and 2. These were, of course, the first written terms signed by the parties in relation to this project. And we say they are important documents. I accept that the intention was that they would be overtaken by the November shareholders' agreement. But we say that the Lordship can look to them as aids to construction, and the Lordship can look to them for any lacunas that are left undealt with by the November agreement. So they set out. Now, of course, both of these agreements were entered into before any of the team, Mr. RELLA, Mr. Turtle, and Mr. Guerrero, before any of that team left the VJ at Hilton. So these were quite important, we say, for the team, because these assurances would influence them in handing in their resignation. And the first one, just flag up the points, we have obviously the shareholdings agreement. Under that we have shareholder B would agree to give his name, ROBERTO'S, as NewCo company name during his permanence at NewCo. We have an agreement at the bottom of that first page in relation to the entry fee. Over the page we have shareholder being, third paragraph down, shareholder being in charge will be in charge as managing partner. It sets out the employment terms. It sets out an entitlement to family medical insurance and indemnity as per UAE law. And then at page 10, page 10, in the May agreement, in page 10, at the very end, above the signatures, note only Amin Chadwick and Roberto will be shareholders in all the additional, I'm not sure if that's a type draft there, but ROBERTO'S, restaurants and lounges, with an ownership split 90% for Amin and 10% for Roberto. Now, Mr. RELLA says that he afterwards negotiated that away and also negotiated timings for the entry fee. And we find that in the July agreement, which is at tab 2 in the Lordship's Court bundle. And if I can just show your Lordship what's different in this contract, in this agreement, if your Lordship looks at the preamble at the top, the words note, if for any reason, to the end of that paragraph, they are new, they will appear in the May version.
Which page are you asking me to look at?
Page 11, you should have the July.
Yes, of course.
At the very top, you should have the preamble, the exclusive restaurant will be located ideally within the World Trade Centre as well. And then the words, 3 lines down, note, if for any reason the lease is not signed. Those are new words, they came in the July version, not in the May version. And other than that, the first page is the same. And then if your Lordship looks at page 12, there's a slight adjustment in the May version, the employment salaries included reference to accommodation. So for Mr. RELLA, plus housing allowance brackets apartment with 3 beds. That's been changed to fixed amounts, so housing allowance of up to AED 140,000. That's a change. The equivalent change occurs both in relation to Mr. Turbo and Mr. Ribeiro. And then if your Lordship looks at page 13, above the signatures, your Lordship will see that the ownership split is gone. And your Lordship will also see underneath the signatures there's this note in relation to timing of the payments. That's new, that wasn't in the previous version. And we say that at the time these agreements were very important, I've already made that point, and that's emphasised by the parties wanting to stipulate exactly when the 100,000 is paid across. All the Articles of Association are at tab 3 in the Court bundle.
Is it common ground that the words Roberto Restaurante are a mistake for Roberto Restaurante, or doesn't it matter?
Well, that would be our position.
My Lord, yes, I think we're in Lord Hoffman territory.
Well, this is an alligator.
Or Alice in Wonderland, or whatever metaphor wants to go down.
Well, the Articles at tab 3 nothing very remarkable about these. I'll just point out a couple of things. Firstly, Article 2 would have the definition of the company's name. 38. On my copy, the numbers are obscured, but company objectives is number 4. And then if your lordship looks at 4A, it says restaurant in the name of Roberto's Restaurant, LLC. And then it says this, pursuant to a licensing agreement for the rights, the name and trademark from Roberto's Restaurants Holding. Somebody's got some question marks, I'm not sure who.
Did you get a better version of this in Corbyn?
It's not better in the main bundle because my version I've taken out of the main bundle. And I've had to write in. Look, can we see if we can do something about that? Because I agree with this.
Both versions have been copied in such a way that one can't see the paragraph numbers. Would it be possible to have a copy in which we could see the paragraph numbers? When these documents are put together, presumably by somebody in the office of one or other of its advocates, does anybody ask themselves whether they're useful to the judge if you can't see the paragraph numbers? Because if not, do you think that would be a sensible thing for somebody to ask themselves?
No, I'll pass it. You have page 38 and then below the section we were just looking at under company objectives, share capital. I was just going to show your lordship at the very bottom of that page, D and D, which record Mr. Cadry's contribution by way of both share capital and loan. And E says the total amount paid by Emain Chadwick less his share capital as in C shall be accounted for as a shareholder high preference loan to the company and to be paid back within 5 years of the incorporation date prior to distributing any profits or dividends. Mr. Cadry's evidence and indeed the accounts support this. He put in around about 7 million by way of share capital and an additional 7 million or so by way of the loan, bringing the total money that he put into the project to 15 million euro. There's some suggestion that possibly the share capital is also low. I haven't been able to reconcile that. If that's right, if I've understood that right, I haven't been able to reconcile that with Article 5. Because Article 5 draws a clear distinction between monies put in as capital and monies put in by way of loan. The capital ranks pari passu, but the loan has preference. Maybe I'm missing something, maybe I've misunderstood, it may not matter. But that's as I see from the article. Article 7, which is barely readable over the page, it's admission of new members. New members require a special resolution. general meeting, subject to the law, an annual general meeting and any extraordinary general meeting shall be called by at least 21 days notice to all the members and managers. That's mandatory requirement. I don't think we need to look at anything else apart from this one over to Article 17, which is disqualification and removal of managers. A manager's office is automatically vacated if needed, and then there are various matters there. And number 6 is removed by resolution of the members. Now, it must be a resolution of the members of general meeting.
When I last looked at this clause in connection with the grant of interim relief, I think I formed the view and expressed it in judgment that it was not at all easy to see that any of the events in Article 17 had actually happened in this case.
That's what we say.
And is that still in dispute?
I don't know, but we certainly say that Article 17 is not going to happen. If I can just show you also as well Article 21, proceedings of the managers. I and J.
Well, can you just help me with this?
Yes.
Have we got a copy of the members' register?
Well, I don't believe we have.
Because the definition of member is someone whose name is entered in the members' register. So if I want to know who the members are, the members' register would be the place to look.
Well, that's right. The article specified that the only 2 members who are going to be registered as members will be Mr. Chadwick and Mr. RELLA. But that's initially. And the shareholders agreement specifies that Mr. Turgle and Mr. Mugavero will not be members, but their shares will be held in trust. Now, I'm proceeding on the basis that the register of members should record 2 members at the moment. But we can't.
But they're not members. They're not registered and they're not members. They won't have any shares.
They don't have any shares. They have a beneficial interest in shares held by Mr. RELLA.
And the claim to forfeit Mr. RELLA's shares, is that a claim to forfeit the 30% or some lesser amount?
I think Mr. Kadri says that he can take the 30%, but he will hold Mr. Mugavero and Mr. Turgle's interests on trust for them. I don't know Frank Martin. So I don't think there's an attempt to take their shares beneficially.
Well, where's the forfeiture clause?
The forfeiture clause is 3.9 in the shareholders agreement, which is at tab 6. last line says shall render his shares. Doesn't say who to. Render can mean surrender or give back.
Well, just at the moment, I'm struggling to understand why it's said that the company ever issued any shares to Mr. Chadwick or Mr. McGrath.
It didn't.
But if it didn't ever issue any shares to them, it's difficult to see why they could be had sending giving anything back.
No, not true, obviously agree with that.
And the only person to whom shares have been issued seem to be Mr. Cadry and Mr. Rella. But it would be helpful to see them when we're at register of members.
Well, it's not in our hands, but I'm sure it's going through the
Well, we'll make some inquiries, but just to be clear, we're not selling the individuals having sort of value signals as well. He wants those shares on a beneficial basis, nothing more. But once they are returned to either the company or Mr. Carter.
Well, it may become necessary, Mr. Brown, in due course, to understand what it is that Mr. Rella is said to have forfeited.
I was going to show you also the articles, Article 21. I and J contain an absolute bar on managers voting if they have a direct or indirect conflict. And J precludes a manager who has a conflict being counted in court. Contract is the employment contract, and that's at tab 4 of the court article. The relevant provisions are clause 6, which provides for medical insurance. And then clause 7A are the airfares. C, holiday. And then F is the sick leave provision. It gives Mr. Rella up to 90 days. Full pay, sick leave, after his first 6 months of employment. So you should remember from the employment law it's 60 days. The contract gives him it's on terms. We've looked at clause 8. There's nothing more we need to look at there. And so, I'm not sure what should add anything concerning the shareholders' agreement itself. And that is at tab 6.
Well, you described this as the shareholders' agreement, but actually it's headed draft shareholders' agreement, and it's not signed.
Tab 6, I think we're
Signed
on
one
the
is
signed
signed.
version. Tab 5 is the draft.
It's actually tab 6 is
Hopefully
signed.
tab 6 your lordship has the signed version. Yes.
Yes, it's still called draft.
It is. Well, the heading remained on the final version.
So why do I need tab 5?
Well, I suspect that the learned friend will want to cross-examine on tab 5 along the lines of, well, you had this agreement in August, you had 3 months to think about it, so last night you must have had exactly what the learned friend's nodding. I think I've got the line of cross-examination, so I think he would say it's quite an important document.
Are they different?
Not materially different, I think. .2 is the same. 3 point. 9 is the same. I must confess I haven't done a line by line check. 3.5 I'm told is different. In the draft, there's an error on the share allocations to RELLA. It's clearly an error because it doesn't have up to the 100%. And the words, after repayment of share capital over a period of 5 years, the parties agree, the parties become shareholders. Those words will be used here. But about 2.2. This is the use of the name. It says the company has been formed under the name of ROBERTO'S restaurants. The name of the company should be changed to ROBERTO'S LLC. Referred to as the name. And then the name was fully owned by the first party and or its affiliates. And in case this agreement is terminated and the company liquidated, the name and all intellectual property rights deriving out of the name, such as trademarks, labels, trademarks, and then shall stay in the first ownership of the first party, but not vendors and or its affiliates. Affiliates is a defined term, and given that we're talking about Mr. Chadwick as the first party, affiliates means entities that he either controls or which control him or which are under common control. That's at page 151. I don't think Mr. Chadwick is under anybody's control. So the only thing we need to worry about is who did Mr. Chadwick control, or what did he control, directly or indirectly. And we say he controlled both the company, because he was the majority shareholder, and indirectly controlled Mr. RELLA, because Mr. RELLA was an employee of the company. So the words and or its affiliates can include both the company and Mr. RELLA. Now, my learned friend will point out, well, you may have the words and or its affiliates there, but they don't appear later on. Four lines down, 3 lines down. And we say, well, if you read the sentence, if they're owned now by a first party and or the affiliates, it's not a great step of construction to say that the default provision that then follows must be referred to the first party also and or its affiliates. In other words, whoever owns it now will own it after termination. We say that when the lordship sees the full picture, it becomes very clear what was actually going on here. But I'll say that if I make the exploration across the issue. But that's the course as it stands. And then turning to section 3, the learned friend in his opening refers on the last on 3.7. So I point that out. I think this is part of his argument that these shares really weren't worth anything to us, because everything was very uncertain as to what would actually happen. But there's 3.7. 3.8 is the advance. I don't think I need to say anything about that. We say it can't possibly apply in circumstances where we've been wrongly ousted from the company because we've been deprived of a fair opportunity to repay that advance from incentive payments. And then 3.9 obviously is important. We say this is an egregious clause. It must have been obvious to Mr. Chadwick that we cannot have in any way anticipated its ramifications. The forfeiture provision has no time limit. It provides for no compensation. It provides no other right of review or redress. It carries with it no commercial benefit to the company. Mr. Chadwick, in exercising his powers under this clause of dismissal, would have an obvious conflict of interest. Well, it would be very surprised indeed, we suggest, if this clause was upheld by this court. No time limit, no compensation, no appeal, no point. And it's tainted by conflict. My learned friend had his best stab at justifying this clause in his opening. Can I just show you a couple of paragraphs in his opening? Paragraph 30. His first attempt is to suggest that the clause, his words, is to lock the key individuals into the business. Well, that makes no sense at all. If the purpose of the provision is to lock somebody into the business, it should do one of two things. It should give them an incentive to stay and not resign, or a disincentive to leave and resign. That's what locking someone into the business is about. But this clause doesn't operate on resignation. This clause operates on breach.
Well, it does operate on resignation, doesn't it?
Well, within the first 5 years, but that's not what I'm complaining about. I'm complaining about the second part of the clause. I quite agree the first part has that effect, but it's the second part that I'm concerned about. And the second part operates indefinitely. So you could have a situation where Mr. RELLA spends 20 years in the business and builds it up, toils, sacrifices his life and other opportunities, builds up this business to be worth millions, the global brand that Mr. Chadwick wanted to build. And then one moment of foolishness on his part, one ill-thought-through act, the night before his retirement date, just as he's about to take his family away and live out his years somewhere home, he will reap the benefits of all his work. One act of foolishness. That's it. He loses it all. Can't be right. Can't be right. And the only difference is it's that part, of course, is a lot key individual for the business. Well, that part, of course, doesn't meet that perfectly. And then the second time that the letter returns to this is at paragraph 43 of the paper. And this is telling, because here we see the error, in my submission, in the plaintiff's position. He says, in summary, the shareholders' agreement was an agreement drawn up by parties with full access to individual funds. And then he says this, it's not a penalty, as it does not arise on breach, and there is a legitimate commercial justification in it that it ensures the safety of the venture and removes an individual in breach from participating in the future fruits and management of the business. That I understand. But that's not what I'm complaining about. I'm complaining that the clause deprives, forfeits, the past fruits of his toiling business.
You're not relying on the powers relief from forfeiture.
Well,
I thought this was a forfeiture clause rather than a penalty clause, but you again asked me to look at it like that.
Well, I've said, I don't know what I think about that, if I may.
And it operates to forfeit in the event that somebody leaves voluntarily, among other things.
Well, it does.
And in no way could that be regarded as a penalty. Because there's no obligation not to leave voluntarily.
No, there's the part of the clause that I'm complaining about is not the first part. So, although the share capital loan grants are paid in full, in case the second or third party, fourth party, leave the company and or the restaurant and resign from his position before completion of 5 years from the date of operation of the bid threshold, stop. Or, we say what the penalty provision is. is dismissed from his duties and opposition for serious cause. And what we say is that's a provision there's a whole over Mr. Rowley throughout. It's a deterrent. It punishes him if he's found in serious cause in most draconian fashion.
Yes, but it doesn't do so by way of imposing on him the liability for damages.
Well, it doesn't.
You don't want to rely on forfeiture, that's fine. You won't spend time on it.
Well,
But the provision is certainly a curious one. There was a schedule for this trial. Can you point me to where it's got to? It was included in a batch of documents which Mr. Downs said. So I haven't printed it out. I just wondered if we have a copy. A time schedule. Have you seen it before, Mr. Downs?
well, I have seen it. Well, I know your worship's going to say that I'm running over. And I'm happy to sit there.
Well, you have it taken up. There has been a period that was allotted for opening statements. And I just wondered if you're asking me to revise this. As I say, we can tell Mr. Rella he doesn't need to come back to us tonight.
Well, I think I can finish all that I was saying about this. A lot of what I've said has intended to be non-controversial.
I'm going to be very brief because this is probably only something which the service and the mutual is approaching. Helpful now by the key areas of disputes. So it is my sentence.
I'm more grateful for that. Well, can I just take another 10 minutes, just very briefly finishing off? Can I just repeat what I said earlier? Your Lordships, I did initially say that we were not relying on forfeiture. Your Lordship challenged me, and I said I'd just like to think about that a little bit. So at the moment, I would like to just think about that a little bit more with you, and that will happen in options.
Mr. Downs, I'm not challenging you. You can rely on it or not as you choose. I just want to know what the position is.
Well, of course.
I mean, if you're not relying on equitable relief and forfeiture, I can forget about it. The fact that I may have thought that it was probably your best point is nothing on that. It's for you to choose your points, not me.
Well, I'll accept. So on unfair prejudice, there are 4 grounds of unfair prejudice that we rely upon. One is the exclusion from management. Secondly, the attempt to forfeit our shares. Thirdly, the misappropriation of the name and the intellectual property associated with the name. And fourthly, possibly dividends, depending on how cross-examination goes. We do not rely on the failure to deliver orders, which was really as being granted, nor does there's no additional prejudice. Well, in relation to exclusion and the dismissal, we say there's no cause under the service agreement. There's no misbehaviour under the service agreement. There's no cause under the Act. And there's no serious cause under the shareholders agreement. In relation to the clause 3.1, we state it's a penalty clause. We say it's not satisfied anyway, because serious cause isn't laid out. We say that in it's a quasi-partnership, the lordship can nevertheless, even in the face of the original fact find that our treatment has been unfair and remedy a position that way, and we have to fall back in mistake. Because I said, I think, again, really unfortunate. I've explained to your lordship how we put it in relation to the local law and English law. Well, in relation to the employment claims, we set up a notice period of 90 days, and we say that's reasonable, and we rely on the contract law of Article 63. We say that if the claimant shows cause under the, we accept that if the claimant shows cause under the employment law or misbehaviour under the agreement, that we lose the notice period. However, we say that if the claimant merely establishes cause under the contract, we still need our notice period. End of service for maturity is the same effect on works with both the contract and the law. Well, there's nothing, all the rest is detail, and I'm sure it will be resolved on the agreed or will be resolved on the lordship's findings of primary fact. Can I just have a look at just a short word about the name of the trademark issue, because there is an interesting conflict point here. We say that the jurisdiction for your lordship in relation to the May and the July agreements is established by virtue of their close agreements, close connection with the IMC, and also because we have relied upon them in our counterclaim, and no point on jurisdiction is taken by the other side. So the lordship has jurisdiction under those agreements. We say that the May agreement was a license by Mr. Rella to the company, allowing it and it alone to use his name and the goodwill he built up associated with that name. It did two things. It gave a right to the company and recognised the right of Mr. Rella. It gave nothing to Mr. Chadwick. The agreements, and your lordship will hear in the evidence, and Mr. Chadwick says himself in his statement, these parties have a much bigger vision than this restaurant into the IFC. Mr. Chadwick wants to build a local brand, and he wants it to be called ROBERTO'S. Now, in the shareholder, in the original agreements, the May and July agreements, Mr. Chadwick is a party to those agreements. He's bound by those agreements. And so, what we said, they established the default position in relation to that name. We say that once one gets the shareholders' agreement upon which my learned friend relies, when you read it against the admissible background, it didn't change the default position at all. And indeed, when we get into the detail of the evidence, we shall say that Mr. Chadwick took steps to reassure Mr. Roberto that that was all going to be dealt with in a separate agreement. We didn't need to worry about that. We say that the private rights that surround this trademark are not a federal matter. We say that the federal courts and the ministry have no jurisdiction in relation to the May and July agreements. They have no jurisdiction in relation to any wrongness Mr. Chadwick is against the company. They have no jurisdiction in relation to the shareholders' agreement or unfair prejudice. All of those matters are for his lordship. Would you just give me one second? And now my only friend is going to say, well, because the federal courts have jurisdiction over trademarks, your lordship can't look at this issue at all. And we say that that's not right, that the legal rights that are associated with intellectual property in the DIFC come from two sources in this respect. Firstly, federal law, but also private law. And private law rights are within the jurisdiction of this court. And we simply, we draw the analogy between the position in England pre-Judicature Acts, where you might have, for example, also common law saying, well, there's only so far we can because we will just look at these facts and these circumstances, and the courts of equity say, well, we'll look at the broader picture. And the federal courts, because Mr. RELLA complained about the trademark being registered, and he was turned down, he was given short shrift. But that's because the federal courts were just looking at the federal law. They weren't looking at the private rights around it. And we say the lordship can look at those private rights and can do justice.
What are you asking me to do in relation to the trademark?
We're asking, our primary ground for relief is we ask the lordship to order that Mr. Chadwick transfer the trademark to Mr. RELLA.
Where's your card?
It's in front of your table and tab 2. Page 33, paragraph 49.4. And 5.
That is as part of section 134 relief, isn't it?
Well, it is. So we say your lordship can order either the primary position is we say that our name was taken wrongly, and your lordship can order it to be given back. The secondary position is your lordship can order the investment in the company.
The trademark isn't your name, it's a mark.
It is, but it's intellectual property associated with the right to use the name. The right to use a name will carries with it a whole package of potential private rights, private law rights. And the trademark is simply one aspect to that. It's an item of intellectual property.
Well, if I want to know what rights the registration of a trademark gives in the Emirate of Dubai, I shall have to look at federal law umbrella.
Indeed. But your lordship doesn't need to determine the rights that it gives. Your lordship needs to determine the rights to those rights. And those are two different matters. Nothing that I'm asking the lordship to do approaches upon any aspect of the federal law and trademarks. I'm not asking the lordship to determine that it's not a sufficient logo or that Mr. Chadwick didn't have the right to register it. I'm not quarrelling with any of that. I'm simply saying such rights as they have, we have rightly or not. If I can give this example, let's say that a party registers a trademark perfectly lawfully, perfectly in accordance with federal law, and then they enter into a share sale agreement, an agreement, business sale agreement, with a party that's governed by DIFC law. And that agreement provides for the transfer of the trademark from party A to party B. Party B's remedy in relation to the enforcement of that agreement lies in these courts, not in federal courts. If he wants to challenge...
At the moment, Mr. Downs, it seems to me that I have to decide whether your client was dismissed from his employment without notice in breach of contract. If you were dismissed without notice in breach of contract, then certain contractual rights will arise, subject to damages. I then need to decide whether you were dismissed circumstances which triggered the forfeiture provision in Article 3.9. And it said what the consequence of that is. At the moment, as it seems to me, and until somebody shows me otherwise, you remain the director of this company in the sense that manager is to be interpreted as director under its articles. If you are a director and you're being excluded from management, then you may be entitled to certain remedies for that offence. I'm not likely to be persuaded that you can invoke Section 134 just because you've been dismissed as an employee. But if I were to come to the conclusion that the effect of dismissing you as an employee is that you cease to be a shareholder, then no doubt you very soon would be dismissed as a director, even if you haven't been already. And that would be something which could be addressed under Section 134. But until I get to the point of deciding that it's unfair to rely on Article 3.9 in the shareholders' agreement, whatever it means, I don't, as it seems to me, get into Section 134 at all. And if I don't get into Section 134, then this position remains that Mr. Renner never had an interest in the trademark and still doesn't.
Well, we say that in relation to Mr. Brenner, the promotion dispute is more than simply Article 134. That the relief we claim on the pleading covers also the May and June, July agreements. That's how the case.
Well, that's a bit difficult in circumstances that the shareholders' agreement includes an entire agreement clause.
It does contain the entire agreement clause.
And if I have to decide whether what has happened is unfair and oppressive, I'm not actually looking at the articles, I'm looking at the shareholders' agreement.
In relation to Mr. Rella, the only way I can get home on Mr. Rella is to persuade your lordship that the shareholders' agreement contains the lacuna that I can flag up for you. That lacuna gives me the right to go behind the agreement and go back to the earlier agreements. But could your lordship, I understand where your lordship is coming from, but there is quite a bit of evidence about what's going on. And I'll just ask your lordship to wait until that evidence comes out. That's Mr. Rella. With the company, I have a...
And the evidence is going to go to the question whether or not Mr. Rella was unfairly dismissed, isn't it?
On this point, it will go to construction clause 2.2 and the entire agreement clause. So, Mr. Rella, I have to somehow get past the November agreement and get myself back to the May and July agreements. I accept that. For the company, the position is slightly different. For the company, I can rely on Article 134 because I can say that Mr. Kadri's actions in grabbing the trademark for himself without any authority from the company as members was a breach of his duty to the company, and he's accountable to the company for that. And that can fall, that wrong can be righted through the mechanism provided by Article 134.
Can I look at 18, little 1 of your defence, page 25, in overlay. I'm led to think that it's in issue as to whether the document attached 6 of the core is authentic or not.
It's not in issue anymore.
It was in issue.
It was in issue.
Has that ever been amended?
Well, now just
On the face of the pleadings, Mr. Brown has come here to meet an allegation that he's relying on a document which isn't authentic. Is that not the position? Because it's so rather important. And in essence, your client was pleading forgery. And that's been... Well, if he was pleading forgery and now isn't, it's rather important to name that in clear terms.
Well, I agree. I thought that the other side were aware that that's no longer part of our case.
There was a letter from one of the Prince solicitors that alleged fraud on that. And it's also said there's misrepresentation, of course, and so on. Back and formally, it was drawn, of course, we revoked it because it's an important sentence.
Well, has the forgery claim been withdrawn?
It's not been withdrawn.
So at the moment, I do have a trial, which on the pleadings at any rate involves me deciding whether a document's authentic.
Well, it's not been withdrawn, but from what we understand from Mr. Rowland's full statements, he doesn't seek to maintain that. So eventually, it's not a bad person.
Well, it rather looks, Mr. Brown, at the moment as if in order to get that withdrawn, you're going to have to ask Mr. Rowland in the witness box whether he's still alleging your client forged the document.
I'll take great pleasure in doing that.
And I'm quite surprised that rather than have that on the face of the transcript, it isn't withdrawn formally, but it hasn't been.
Well, no, I'll make that the first question.
And I courts are a bit slightly allergic to people who allege fraud and then don't make it clear whether they are pursuing it.
well, outside of you,
What break? The social crisis. While you're thinking about that, Mr. Downs, we'll give the shorthand right, just a short break. We'll take 10 minutes. And when you come back at 12, actually you can tell us what your position is on.
I know the wire is here. Yeah. Yeah. They were on this table. What those are. I was going to pass it back, but I had to bring it in. I forgot to put it in this file. So there's no way for me to plug in over there?
Destination point. Destination point. Only visiting source point.
But there's going to be witnesses and an interpreter still there, and I need to be able to control that also sit there.
Yeah, but it what's the connect? What you can display from there?
But I need to change it every 10 minutes. I need to open a new document.
Documents show it shall be good like this pick up. So pick up so that you can automatically PowerPoint or
No, there are videos we need to play.
video. This one is on sale. If you want, I can ask the saving.
So can we just read to have this accessible? I'll plug it in here. It's fine for now. I'll do it from here.
But anyway, now you have to come.
Yeah. Okay. Yeah. Thank you.
like to come and sit close? Would you like to come and sit in front of you? Can we organise that? Or can we? On the loop. Do we have a loop? If he wants to come and sit closer, it's very difficult for somebody at the back to hear council speaking this way.
No, thank you.
If you need to come further forward, we'll make arrangements for that.
Thank you.
Well, the Lordship was asking me about paragraph 18.
Well, the reason I'm asking you about it, Mr. Downs, is this, that there's going to come a time, hopefully today, when Mr. Brown is going to have the opportunity to cross-examine Mr. RELLA. And if I were in Mr. Brown's shoes, I should want to know before I cross-examine Mr. RELLA whether he has to do, whether I had to do so in relation to an allegation of forgery. So we do need to get this cleared up before your witness goes into court.
Well, I'm quite agree. And can I just show your Lordship the position? I think it has been made clear in the amended version. But can I just show your Lordship what our position was on this? Your Lordship took this paragraph 18.1. Now, that is obviously referring back to paragraph 2 of the particulars. So if your Lordship can keep a finger in page 11 and also go back to page 4. Paragraph 2 said, on the 27th of October, second cousin and the defendant, two other persons entered into shareholders agreements. And 18.1 primarily was taking issue with the date of the 27th of October. So 18.1 says, safe to its submitted, the defendant signed a shareholders agreement with the second person, Mr. Turner and Mr. Ruggiero. It's denied that such document was signed on the 27th of October, as alleged. Now, that was the original version. And then there's something added by amendment. Now, your Lordship made a fair point because your Lordship will still 18.1, the word A is underlined, and in 18.2, the word A is underlined. Now, if our Lordship, if I can take an issue on paragraph 20, if your Lordship looks at paragraph 20 sub 2 and look at the words that have been struck through, in the original version, it was said that it was not admitted that the shareholders agreement signed by the defendant did contain any clause reporting to require him to forfeit and then transfer his shares in the event of successful on the grounds of mysterious clause or other grounds, and we put them to strict proof. Now that, of course, raised the spectre.
Which document? I'm looking at. I see. What I've got is two documents in the same bundle. One of which is amended and the other isn't.
If your Lordship looks at page 12, there should be the amended version there.
Yeah.
So your Lordship's point was a fair point, because in the original pleading, whilst we hadn't pleaded a positive case on forgery, we said that we don't admit that. And the reason for that was simple. Mr. Brennan was very surprised when he saw these clauses. So there was a non-admission. When the amended version was served, after disclosure had taken place, and obviously everybody reflected on the material, that non-admission was deleted. And if your Lordship looks down at 3, it's the same point again, the word struck through. The defendant affirms that if which is not admitted, we did in fact sign a shareholders agreement
which the matter of fact contains such a forfeiture clause, is it that yours induced or procured by misrepresentation. That then struck through in the amended version.
So is there now an admission, or do they have to prove it?
No, we admit it. We admit that the document on the 21st of November containing those clauses in the form relied upon by the claimant. We admit that we stand by it.
Thank you.
That was all I was going to say by way of opening. I do apologise. The motion for it.
Thank you. Yes, Mr. Brown.
Well, I'll try and be brief. As I said, that was helpful and relatively neutral. So it certainly put before you the areas of conflict between us. I just want to refer to some of the matters in the agreement that are relevant. And if we start with the contract of employment, because as I say at the start of the skeleton, the conduct of Mr. RELLA is really crucial for each of those for you. If we're right that his behaviour is as we've characterised it, it's justification for termination, justification for forfeiture of the shares, and there are obviously other consequences that will flow from that in relation to the directorship as well. But if we start with the contract, I'll just show you the differences between us. This is in the core bundle, but divided for. And you'll note that the terms of employment at 3A include a number of obligations. So, for example, 3C, to use your best endeavours to promote the interest of the company. And
It's very difficult to see from the last page when this document was signed, but is it accepted? It is the 5th of June 2011.
it is on our part, yes. It is on the other side of the part as well. 3D that he agrees to abide by the UA and DIFC, and also all lawful orders and intercompany policies and precedents given from time to time.
Yeah, just looking back page to the last page of tab 3, the articles were signed on, also signed on the 5th of June 2011. These, what was the date of the incorporation? We got a certificate of incorporation.
I don't think we have.
It's 26th of May, and it's in effect, that's what's been in paragraph 13. And it's also
26th of May.
26th of May, it's in Guevaro's acceptance. I think it was in Guevaro, that paragraph, that's not it.
Do we have the certificate of incorporation?
I don't have it on my list here, I would suggest we don't, because I'm looking at it. Mr. Cadry says is that date as well, paragraph 14.
Yes, you want me to look at the employment contract?
Bundle 3, page 597.
Level 3. So when incorporated, Mr. Chadwick was the service manager. That's from, well, that's what goes from the details. And it was 597 is actually a later document.
I might have to come back on that. We're not sure that we're not sure if this is a later document or contemporaneous.
But it's just if you look down the right-hand column,
Yes, I see
way up from the bottom, you see Mr. Cadry's name is the service
Yes.
manager.
Yes.
And the certificate of incorporation has on it the date 14th of May 2013. 12 Probably it's the date it was extracted from the file. It's inadequate.
I don't think this is the,
Which doesn't seem to correspond to it.
no, I don't think this is the certificate of incorporation. I think it's an extract from the.
You don't think 596 is the
I
certificate?
think I've contributed on documents. I don't think habits will be fine by them.
Yes.
Oh, sorry, I was taking you through the contract, and obviously 3C and D restate material, and of course, as in all employment contracts, there's the duty of trust and confidence and fidelity which are both implied. If we go to clause 8, there is a difference in interpretation between us, and when we're together we accept it's not perfectly drafted. See the definition of clause. Here we're concerned with is fraud, embezzlement, gross negligence, self-dealing, theft, asset relocation, stock mishandling, unauthorised transactions, commission bribes, dishonesty or other gross and willful misconduct which has caused serious and demonstrable injury to the company. And we say, of course, that that's got to be construed purposively. I think there's a suggestion in the witness evidence that whatever his conduct, he didn't actually cause any actual damage to the company. Now, if we were going to explore that in some detail, drafters would be here for 2 weeks. But we say you give that purposive interpretation because if the company genuinely feared it might lose the liquor licence because of his conduct, it's entitled to rely on that clause. We don't have to wait for the damage to occur. Simply common sense to apply it in that way. But as I say, I'm not clear as to whether that is a construction being advanced that you need actual damage before you can activate it.
Where do we find the document in which you gave notice dismissing him?
That is in bundle 3. In the January extract. Sorry, it's in the April extract, sorry. .583.
He was suspended in January and dismissed in April.
Dismissed in April, and that's page 583 in bundle 3. Not familiar enough with the other side's 4 bundles to tell you what it is in that, but it's. It's tab 26 in the appendix for bundle. material to look at clauses 8C, 8F and 8H. And they cover material violation of material company policy, knowing and intentional failure to comply with applicable laws, and exhibiting use of alcohol or drugs which materially interfere with performance. There's a difference between us on 8C. Mr. Down says, well, misbehaviour must be more serious than what's envisaged in 8B. We say that can't be right. 8B reflects the position of a repudiatory breach of contract, so gross misconduct. I can't think of something that goes further than that in seriousness. So to say that misbehaviour, which is clearly a lesser concept, results in deprivation of the duty service and obviously the requirement to give notice, but gross misconduct simply doesn't work on the normal application of general principles. It clearly should encompass and does encompass gross misconduct as well as misbehaviour. So it's either gross misconduct of serious cause of the state's misbehaviour, or you still lose those rights in relation to that serious cause and gross misconduct.
Where in the contract is the provision for payment of gratuity on termination, or is it under the law?
It's under both, in fact. It's
Can we just see them?
yes, sorry, it's just get my highlights on it.
Well, it's 8C gives a end of service gratuity in accordance with Article 60 of the law.
Yes. You certainly don't get double recovery.
My recollection was that there was something in the law which provided for it. Can we just have a look at Article 60? It's it should be Article 62, shouldn't it? Yeah. Article 60 is a mistake.
Yes, I picked up the mistake in that you lose the right to the gratuity if you've been dismissed for cause as defined in Article 59.4. Of course, 59.4 doesn't define the cause. It should be.
Well, that's two two mistakes. I mean, the first is the one in the agreement, which refers to Article 60, whereas it should refer to Article 62. And the second is that in Article 62 it refers to 59.4, whereas it should refer to 59A. Was that because the employment law was amended? It was amended in 2012. It may be that that's the explanation.
Possibly.
It may change. So 59A is in fact in very much the same terms as little d.
That's our basis. I think that the defendant says that there's a difference in each of the tests under either the shareholders' agreement, the contract, or the statute, so the code. But we say it amounts to the same thing.
Yeah, what they both do, what 59A and 8, the little d does, is they graft onto the conditions for summary dismissal the requirement that a reasonable employer would have terminated.
Yes.
So that's an additional condition.
It is.
Which needs to be satisfied before the right to gratuity is lost.
Yes. I mean, the traditional analysis is that you start off with the minimum rights in the code. If you enhance them in the contract, all well and good, but you can't derogate from them.
So if you didn't have little d, you'd still be in a position under Article 59A that you would get your gratuity even if you were dismissed for cause with capital C. I think, wouldn't you?
Well, no, because so if it adds the, you still have the same facts on which the employer is relying, but you've got the degree of external supervision.
Mr. Brown, I think I didn't put the point clearly.
Sorry.
If you didn't have little d, you would still have a combination of 59A and 62.4, which would lead to the conclusion that even if you were dismissed under 8 little b for cause with a capital C, you would still be entitled to your gratuity unless the case was one in which a reasonable employer would have terminated your employment.
Yes. Sorry, I misunderstood.
So that additional requirement is incorporated into the contract, either expressly under little d,
Yes.
or by virtue of the statute provisions of the law.
Yes. It looks like it's an odd.
And you wouldn't get rid of it simply by having a definition of cause with capital C.
No. But in any event, I'm not sure it adds an awful lot to it, because in any of these cases, where there's a gross misconduct allegation, the court's in that supervisory role anyway. I think it's simply been lifted wholesale and, of course, inaccurately from the statute, because how does an employer decide, am I being reasonable compared to other employers?
The court has to do that. At the end of the day, if the employer dismisses the employee summarily because one or other of the paragraphs under little b are satisfied. He still has to pay a gratuity unless the employer can say, well, not only did I dismiss him in circumstances which warranted termination, but a reasonable employer would have done the same.
Yes.
So the obligation remains on you to satisfy that second condition if you want to avoid paying a gratuity.
Well, that's right. So as I set out in my skeleton argument, the analysis in the English courts, to the extent it helps us, it gives us a very marked appreciation. It's not no employer have dismissed, because doubtless Mr. Ruggiero is going to say he'd been quite happy to have Mr. Rella conducting himself as he did. But we say that's irrelevant. There are a range of responses, and the courts give a wide margin to the dismissing employer. I don't see that removes any objective.
I see the point.
I don't see that removes any objective supervision, but it certainly does restrict it.
Anyway, you say that analysis along those lines explains what little d is doing in this model.
Yes.
It's reminding us that the statute provisions will protect the gratuity.
Yes.
Unless this was a case where a reasonable employer would have dismissed. Rather, and I notice actually that it's not a reasonable employer wouldn't have terminated the employment, he would have terminated the employee. Seems a bit harsh.
Well, different places have different social mores and penal consequences for wrongful acts, and far from me to suggest it's right or wrong.
Anyway, I think you're entitled to rely on the statute. You don't have to show that a reasonable employer would have terminated this.
No. We might not be here today if we had.
It might be somewhere else.
So that's really the observations on the contractual aspects. There's another point on the shareholder agreement. Mr. Downs outlined, so it's my second point, Mr. Downs outlined the differences between the interpretation of clause 3.9. One of the points he says is, unless that provision comes from the compensation code, it simply can't be relied upon. We find that rather, well, puts that case rather higher, because of course the code doesn't provide for delivery up of any sort. So is that to suggest that any contract with the DIFC for delivery of goods for non-performance or for breach is simply invalid? Can't be right. But on the face of it, we say that's an enforceable clause and not a penalty for the reasons that have been advanced in the skeleton argument and explored in argument between yourself and Mr. Downs.
It may not matter in this case, but I'm not at all persuaded of the amendment that the phrase or is dismissed from his duties and or position for serious cause was not also qualified at the 5-year time limit.
That's one of the arguments that we're going to do.
And I appreciate that the natural reading of the clause might suggest otherwise.
My Lord, we say 5 years qualifies both in the alternative that there are reasons for removing somebody from the business and the shareholder if they've committed sort of misconduct envisaged.
It may not matter in this case, but it's seems to me at least arguable that the phrase 5 years from the date of operation has actually got itself into the wrong place, or alternatively, the words within the commas always dismissed as being inserted in the wrong place. But that is.
Yes, that's a construction we may adopt if we need to. So far as the...
What I do find more difficult actually is just how this clause works in relation to Mr. Turgle or Mr. Rivera, given that they're not in fact shareholders.
Well, as I indicated, I think in one of the helpful interruptions to my learned friend, we intend, if the shares are rendered to the company, there will be something declaring them to be held on trust with those two individuals in the same proportions. And if we need to get enough to take into the court, we can do that.
I think, Mr. Brown, the problem is a bit more fundamental than that. I mentioned it, so that you consider whether you want to address it. It would be a very odd result if Mr. Turgle or Mr. Rivera were deprived of the beneficial interest in the 30% shares registered in Mr. Rella's name because of something that Mr. Rella had done. And that would be a pretty odd result.
Yes.
And if that is the result that 3.9 is intended to have, it would be a pretty draconian clause.
We don't think that... Well,
Which is why you are peddling hard to try and persuade me, first of all, it wasn't meant to have that effect, and secondly, it wouldn't give that effect anyway. Well, the clause is the clause.
The clause is the clause, but the parties were well aware as to the beneficial ownership of those shares. Prior to and subsequent to the entry into the clause. I'm not peddling hard, I'm simply expressing what we see as the justice of the situation. I accept that if the clause does mean they would forfeit their beneficial interest as well, then it would be justified. That beneficial interest is reflected in page 227. Previous page in the core content.
Yes, I can. Well, well, it wouldn't be actually that they were forfeiting their beneficial interest. The fact is there wouldn't be any shares to have a beneficial interest in if the clause works as it says it works. You're going to explain to me how 3.2 works. This document is dated and executed sometime after the incorporation of the company and the signature of this articles. If we see the register of members, and if the register of members is consistent with the articles, it should show Mr. RELLA as registered in respect to 600 shares. Now, if that's what the register does show, I don't see how these parties, including two who aren't members at all, can assert that the share capital is held as to 1,998 shares by Mr. Chadwick and 2 shares by Mr. RELLA. What shares have been issued to this company will turn on what the register of member shares. What they can do, I think, is to agree that the shares which have been issued are held beneficially in some other proportions. And that's what they seem to be doing at 3.5. But it's not very easy to reconcile 3.5 and 3.2.
No, it's not. Our understanding is 3.2 is a mistake, and that the true reflection is at 3.5.
I think 3.2 is a mistake.
Doesn't call the terms accurately.
Well, 3.2 amendment reinforces my view that whoever prepared this document didn't know what they were doing.
My Lord,
Which is not for you a very satisfactory state of affairs if you're relying on 3.9.
well, my Lord, just because there's an area in one place doesn't mean the J is elsewhere. And we say that the intent of 3.9 is quite clear, and the effect of 3.9 is quite clear. I mean, the fact that it's headed draft, I don't think anyone suggests that affects the contents of it anymore. Well, so far as the rights to the name are concerned, there is the trademark issue, which I'm not going to go into some details as yet, but just so that you can see what was actually registered. It's the next, it's divider 8. Trail starts with the Articles of Association, which you see at divider 3. If you look at the objectives, over at page 38, it's our submission that the name was never to be owned by the first respondent. Yeah, so, and that's what's reflected as shareholder agreements and clauses. Told that this is a document produced by the defendant, and it's somebody in the defendant's legal team who added the question marks and the line. Which you see it's on other documents as well. First claimant chose not to own the name, and we say that's reinforced both by the Article of Association and by Clause 2.2, then it really can't be said that there's any breach of fiduciary duty by my client, Mr. Carter.
Well, if the name is owned by Mr. Chadwick, then why is the company going to get a licensing agreement from something called ROBERTO'S Restaurants Holding? What is ROBERTO'S Restaurants Holding?
It was envisaged that would be the body, but it was simply never set up.
And if you go to the articles, it doesn't suggest that the company is going to get a license from Mr. Chadwick.
No, but if you look at the shareholder agreement, certainly that suggests that it will get a license from one of his affiliates. We certainly don't just accept that affiliates is either uncertain or is apt to cover defendants. All this reinforces is there's simply no fiduciary duty that's been breached by Mr. Cardry, given that the first claimant didn't ever intend to own the rights, name and any trademark.
If you turn the page, it's tab 8 in the core bundle, and you turn to page 304, the registration is effective 10 years from 5th September 2011, even though the registration is 10th September 2012, which suggests that the application was probably made on the 5th of September 2011. And then the document was actually signed on the 26th of May 2013.
My Lord, if you look at page 303, the final sentence of the...
It's submitted on the 5th of, yes. Well, that explains why. So Mr. Chadwick submitted his application in September 2011. which was before the shareholders' agreement was signed.
But after drafts had been circulated, the drafts were circulated in July.
Yeah.
So look, that's the position on the name. We simply say no fiduciary duty and never envisaged that this would be the property of the company, albeit there was to be a company, Roberto's Restaurants holding the name, license the name back to the first claimant. But whatever can be said, it's not a breach of Mr. Cardrew's fiduciary duty in relation to the first claimant that it's registered in his name. The further maximum demand is also if developed by other companies, capable of other companies, and this, you see, it works so it's son as well. In those circumstances, we do find the relief treated somewhat off, but the defendant wishes it to be transferred to him. The alternative, of course, is the first claimant. The only other matter that I want to briefly mention is that under Section 134, we don't think you get to determine this matter. We also don't think you get to determine the effect of Clause 3.9 under Section 134, because that's a contractual issue rather than anything to do with the ability of the defendant to take part in the management of the company. There's certainly authorities that say the equitable powers don't go that far as to rewrite the shareholders' agreement. That's a separate matter. I realise that there are others slightly closer to the line, but I think that's probably a matter for both of us to deal with in closing submissions. Well, there's one final point, and it's this. You're aware that there's some CCTV of the defendant over a prolonged period. And I think you raised that earlier hearing that you didn't want to have to watch that and form a judgment on it. On the fifth witness statement of the claimant, defendant, he's annexed a letter sent by my clients, and I think it's, I'm not sure what to say, is it, you see the updated 274.4.
I think that what I envisaged was going to happen was that you would show parts of this video to a witness and ask him questions about it, or Mr. Downswood.
Well,
what I indicated I thought was not going to be appropriate was simply for me to be shown a video and asked to decide whether somebody was drunk.
we don't.
If that was the question I was being asked to decide.
You're not going to be asked to decide that. I mean, what's said, there's a schedule that we put to the other side which shows the times that Mr. RELLA was present in the bar and the times he left. So, for example,
That's got itself into unlaying.
it's in underlying page 274.4
Yeah,
of the witness statement.
that's the new document. Show me.
There's a table, first of all, which is reference to
Paragraph 6. The only table I've got is paragraph 6.
right. I think it might have gone above somewhere else. I'll try and track it down. I can give you a copy that's clean, and we'll see where it goes. Well, that's a lot of the script and the video footage.
So what I want is exhibit PRR5. But that's an exhibit to the first witness statement of Mr. Rella. I'll hand it back to you so you can see why I said first.
You have the benefit of being able to read the Chadwick, but it should say it's the fifth witness statement.
Yeah, well, it is an advantage before you conflict a judge to read the document he's reading.
Well, my lord, I'm afraid the problem is that
Anyway, I haven't got it, whatever it ought to be. And if I should have it, then it probably needs amending to refer to fifth. And I put it in as 274.8.
yes. Well, I'm asking the other side to sort out the amendment in this written narrative.
It needs amending by Mr. Rella, presumably, who signed it, isn't it? Stating it's his first. Anyway, are you going to take me? When we look at this video, we're going to look at the timed instance by reference to this table.
My lord, we're not going to look at the video because
We're not going to look at the video.
what we're going to look at is the times. Obviously, one cannot tell from the video when somebody's drinking alcohol or Coca-Cola. We're not saying he's drunk. We're saying there's a strong inference being drawn from other of his evidence, the alcohol that he was drinking after hours, and of course the fact that somebody's present at the premises between 1 in the morning and leaves at 7:30 in the morning. Again, common sense to expect that sitting in the bar. This was says, well, I can't tell when I was drinking last night who he was with. We said, Mr. Cardre and Mr. Mossad have watched the evidence. They've given their view as to what they think it shows, and the test is what more can a reasonable employer do under the various threshold test of this.
Do we need this video in court, or are we not having it at all? We don't need it. Right.
And of course, Mr. Rella said, well, I wasn't drunk or being disruptive. Of course, that misses the point. We say mere presence on the premises drinking after licensing hours is something that we take very seriously, and we're extremely worried about the effect alcohol license at the beginning. Loss of the alcohol license would have a catastrophic effect on the business. And it's this is just a sham and attempt to get the shares. But again, you have seen from the contemporaries email documents that even before Christmas in September, there was concerns about the alcohol license would be lost by behaviour of staff. One of the matters that there's two matters that Mr. Rella praised in here. One is well, I was a specialist session. I was always expected to be drinking at the clients till 4 hours. And secondly, if I was to do something wrong, why would I do it in full view? So it's the answer as well. First of all, you had Mr. Cardew, who was not present all the time, and he was very much, well, if anyone's a fiduciary in this case, it's Mr. Rella, because he was honest himself, and the staff were extremely loyal to him. And secondly, Icarus didn't think his feathers would melt when he was too close to the stuff. And that really, in this case, Mr. Rella thought he was the person in charge, do what he wanted, and without any regard to express instructions and or the laws of doing anything. Unless there's any other matters that you wish me to assist you with, that's the only things I wanted to raise briefly by way of opening.
Thank you. We'll adjourn for lunch and sit again at 2 o'clock, and we'll have Mr. Brennan at 2 o'clock. I told you we tested the link with Oregon and it's thought to be satisfactory. If anybody wants to ask the registrar about that, they can do so, but we think it works.